Witnesses are sequestered when the judge tells them to sit outside the courtroom and they're brought in one at a time to testify. Now, this is done so that one witness's testimony will not influence the subsequent witnesses. They won't sit there, watch the direct examination, watch the cross-examination, hear what's said, and then go into the witness box and testify. Now, this is not something that automatically happens. The judge does have the power to, on his own, just sequester the witnesses, but in most cases, this doesn't happen. So one of the two lawyers will need to make a motion to sequester the witnesses. Now, usually the lawyer who is presenting multiple witnesses, in criminal cases, it's usually the prosecutor. They're not going to ask to have the witnesses sequestered. So the opposing lawyer will need to do it. Now, this is done if this is a criminal trial. There will be a trial readiness conference, which will be the last hearing before the trial. And it's usually at that hearing that defense counsel will file a motion asking to have witnesses sequestered. Now, if it's a bench trial and there's no trial readiness conference, or it's some kind of evidentiary hearing, like a motion to suppress, and the prosecutor is bringing in, say, a couple of police officers, or maybe they have an eyewitness and a police officer, multiple witnesses, you can simply, at the start of the proceedings, at the start of the bench trial or the start of the hearing, just make a motion orally to have the witnesses sequestered. There's almost never an objection to this, and the judge will almost certainly grant the motion, even if it's just done orally. I've written a blog post on this, and I'll put it in the description below.